Hello and welcome to the Minimum Competence episode for Thursday, June 12th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, updates on Khalil's detention ruling, Marines in LA protests, the NCAA Title IX appeal, and Trump's push to take his hush money case straight to SCOTUS. Let's remember, one has a moral responsibility to disobey unjust laws and read today's legal news. On this day in legal history, June 12, 1967, the U.S. Supreme Court issued its landmark decision in Loving v. Virginia, striking down state laws that banned interracial marriage. The case arose when Mildred Loving, a white man, and Mildred Loving, a Black and Indigenous woman, were sentenced to a year in prison for marrying each other in Washington, D.C., then returning to their home in Virginia, which criminalized interracial unions under its Racial Integrity Act of 1924. The couple's challenge to their conviction eventually reached the nation's highest court. In a unanimous decision, the Supreme Court held that Virginia's anti-miscegenation law violated the equal protection and due process clauses of the 14th Amendment. Chief Justice Earl Warren, writing for the court, stated that the freedom to marry is a vital personal right, and restricting that freedom on the basis of race was, quote, directly subversive of the principle of equality at the heart of the 14th Amendment. The court emphasized that classifications based solely on race are, quote, odious to a free people and cannot stand. The decision invalidated laws in 16 states that still prohibited interracial marriage at the time, cementing Loving v. Virginia as a major victory in the civil rights movement. It not only reinforced the constitutional commitment to racial equality, but also laid critical groundwork for later decisions involving personal liberty, including Obergefell v. Hodges, which legalized same-sex marriage in 2015. A U.S. federal judge ruled that the Trump administration cannot detain Columbia University student and pro-Palestinian activist Mahmoud Khalil based on U.S. foreign policy concerns. The decision, issued by Judge Michael Fairbairn in Newark, found that using a rarely applied immigration law to justify Khalil's detention violated his free speech rights. Khalil, whose green card was revoked in March, has been in detention since then and was the first foreign student arrested amid the pro-Palestinian campus protests following the October 7th Hamas attack on Israel. The court found that Khalil was suffering irreparable harm due to the damage to his career and chilling effect on his speech. While the ruling bars Khalil's deportation under the foreign policy provision, it does not require his immediate release, allowing the administration until Friday to appeal. Khalil's wife, Dr. Noor Abdallah, urged his immediate return to their home in New York, where she cares for their newborn son. Neither the State Department nor the Justice Department commented. The case reflects tensions over U.S. responses to student activism amid global political conflicts, particularly as Trump-era policies are used to target protesters. The foreign policy provision invoked allows deportation of non-citizens if their presence is seen as harmful to U.S. interests, but the court found it unconstitutional in this particular case. California is taking the Trump administration to court over the deployment of U.S. Marines to Los Angeles amid escalating protests against President Donald Trump's immigration policies. Approximately 700 Marines are set to join 4,000 National Guard troops to support federal agents and protect government property, sparking backlash from state officials who argue the move is illegal and inflammatory. California Governor Gavin Newsom, along with other state and local leaders, contends the deployment violates the state's rights and unnecessarily escalates tensions. The protests, which began in response to a wave of immigration raids, have spread to cities including New York, Chicago, and Washington, D.C., and are expected to intensify with over 1,800 demonstrations planned for the weekend. Demonstrators in Los Angeles have largely remained peaceful, though incidents of violence and aggressive police responses have been reported. A federal judge in San Francisco will hear arguments Thursday as California seeks a restraining order to halt the military's law enforcement involvement. The Marines have completed crowd control and de-escalation training, but are operating under Title X of U.S. law, which authorizes limited military involvement in civilian matters. They're permitted to detain individuals interfering with federal duties, but are not supposed to engage in regular policing. Trump defended the deployment, calling it essential to maintaining order, while critics, including National Democrats, have called it a dangerous overreach. A group of current and former female athletes is appealing the NCAA's $2.8 billion antitrust settlement, arguing that the deal violates Title IX by disproportionately compensating male athletes. Approved by a federal judge on June 6, the settlement allocates 90% of back pay damages to men, largely benefiting football and basketball players. The objectors, represented by attorney John Clune, argue this breakdown reflects a $1.1 billion miscalculation and discriminates against women in violation of federal law. The appeal, filed in the U.S. Court of Appeals for the Ninth Circuit, is the first formal challenge to a settlement touted as a major victory for student athletes. Clune said the agreement lacks meaningful support for women's sports, including basketball and Olympic disciplines, and warned that schools are already discussing cutting programs as a result of the deal's financial structure. Critics of the appeal, including settlement attorney Jeffrey Kessler, claimed the Title IX objection is misplaced in an antitrust case and will delay compensation for over 100,000 athletes. Still, the challenge raises questions about gender equity and how the NCAA compensates athletes for past name, image, and likeness restrictions. While the total settlement amount isn't being disputed, the appeal could impact future policies around compensation, roster limits, and salary caps. The NCAA says it's continuing with implementation, but the appeal introduces legal uncertainty into an already complex shift in college athletics. Donald Trump's legal team is attempting to fast-track an appeal of his New York felony conviction by moving the case toward the U.S. Supreme Court. Trump was convicted in Manhattan on 34 counts of falsifying business records related to hush money payments made to adult film actress Stormy Daniels, marking the first time a former or current president has been found guilty of a felony. His attorneys returned to court this week to argue the state case should be shifted to federal jurisdiction. They contend that Trump's actions were connected to his official duties as president and thus should be handled in federal court, where they believe he might receive a more favorable legal environment. The Second U.S. Court of Appeals is currently weighing the request, which Trump hopes will pave the way for a rapid review by the Supreme Court. The legal maneuvering is part of a broader strategy to challenge the legitimacy of the New York State trial and delay sentencing or any other consequences. Trump maintains that the case is politically motivated and that the charges are being used to interfere with his political agenda. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, civil disobedience is not our problem. Our problem is civil obedience.